Hello, welcome to the DRC conference. Thank you for coming to our session, the Mediator's Playbook, Negotiation Tactics and Strategy for Mediation. I'm Ana Cristina Maldonado. I'm presenting with Sherry Alessar, who's an attorney, a mediator, and a friend, a great educator, and a committed citizen. So I am glad to be speaking with all of you. We'll introduce ourselves here. So from my end, I've been mediating since 2010. I've done about 2,000 cases since then. I'm on the panel for Upchurch, Watson, White, and Max, and I started my mediation career in courthouse mediation in Palm Beach County, working with the Alternative Dispute Resolution section of the Florida Bar. I'm on the executive committee there, and next year I'll be incoming chair, and also started the diversity committee for the section as well. And Sherry.
Thank you, Christina. My name is Sherry Alessar. I am the founder of Back on Track Mediation. I am very excited to have partnered here with Christina today. I think you guys are going to have a good time. She is my mentor. I've worked with her in several capacities, including writing multiple articles for The Common Ground, and served on the committees for both the Mediation Mentoring Academy and the Arbitration Advocacy Institute. I am on the executive committee of the ADR section as secretary on the leadership track behind Christina. I'm also, that's of the Florida Bar, and I'm also in the executive committee of the Palm Beach chapter of the Inns of Court. Having a DRC conference like the one that we have today takes the work of a lot of people. Thank you to Tad David, Mary Beth Bohannon, Kimberly Kosh, Dawn Burleson, Sherry Waits, Ramon Waters, Diwata Thomas, Stephanie McCarty, Shona King Denard, Stephen Banda and Company, and Jeremy Erickson, who is recording us today. This will stream live, but this is pre-recorded, so you can leave comments in the chat box, and we will address them towards the end. I also want to send out a special thanks to Luisa Puerto and Esra Catalane for assistance with the PowerPoint. My legal expertise includes commercial, business, and technology issues, personal injury, consumer products, real estate, and construction law. I'm a member of both the Florida and New York bars, a former Wall Street commercial litigator for Cravath, and former in-house counsel, managing litigation for multi-billion-dollar corporations, including Regional General Counsel of Suffolk Construction. They built the Hard Rock Guitar Hotel, for some of you who may know that, and General Counsel for Legacy Acquisitions, a property development group. I'm also an entrepreneur and one of the founders of a software company called Dason LLC, also known as Apparel Magic. I spend a lot of time with my volunteer work, participating with the state and federal courts in their civil discourse outreach program with local teens. I volunteer as a guardian ad litem. I lecture at Palm Beach State College, judge and coach with Nova Law School's Moot Court and their National Trial Association events, and I mentor and attend educational events like these. Christina is going to give you a global overview of the dynamics of mediation at a much higher level to kind of talk about personalities and get a little bit bigger picture. And I'm going to discuss certain techniques everybody can use as mediators. So Christina, I'll turn it over to you. Thank you.
Thank you, Sherry. So because we spend so much time getting people into a win-win mindset in mediation, it's kind of funny to look at the whole process through the lens of competition. So be prepared for sort of an extended sports metaphor on this one, because it just gives us a lot of language to pull from, right? And it's also language that we can use when we're sort of peeling the jargon out and communicating with the real people who are attending mediation, the attorneys, the parties, everybody else who's involved in the process. So a good way to think about it is, what's the game? We as mediators, we have courtside seats, basically, to all of these negotiations that are taking place. And it does, there are different types of games, both in sport and in mediation. So one good way to look at it is whether you're dealing with a quantitative type game or a qualitative type game. Quantitative, you can have different flavors of that particular type of game as well, right? So is this a distributive game where there's sort of a pot of money and it's a who gets what kind of a situation? You might have dueling claims where everybody thinks that the other side should be the one opening their wallet and writing a check, right? And then you sort of have the step up, incremental, step up, step down, incremental I ask, you offer, I offer, you ask, offer demand kind of games. Then on the qualitative side, you have more complex kind of issues. It's not just about money in that aspect. So you're looking more at a laundry list type format where people have to deal with a certain number of issues. They need to comply with a certain number of requirements. And also in many ways, because nobody goes to court unless they have a problem, you're dealing with what's the roadmap out of this particular conflict, right? What's the way forward? There might be remediation, there might be resolving other underlying issues. So you're trying to figure out what the plan is for the future. So in many instances, you do have hybrid games where there's a quantitative component and there's also qualitative components as well. Also, who are the teams? I'm sure whenever people close their eyes and think of whatever team it is that they happen to root for and whatever it is that they like, you think of yourself wearing your t-shirt or your jersey or your hat and the colors of the team, and everything they do is great and everything the other side does is wrong. And it's that very human sense of unity that the idea of teams kicks in. And that's kind of how people march into mediation, right? Unified front, hopefully. Getting ready to kind of meet with the other side. So when you're dealing with the teams, if you can kind of extend the analogy, you have sort of the players and the coaches. The parties are the players, the coaches are the attorneys who are advising and giving evaluations of what it is that's taking place for the way forward. So what are these individuals like, right? There may be no I in team, but there's still individual humans there. So are you dealing with individuals who are rational or who are emotional? Are you dealing with them coming in from like an ego sort of personality place, or someone who's more humble and is there in the background? Are they a big picture person? Do you have someone who likes to just cut in large swaths and big round numbers and move pieces around in large chunks? Or are you dealing with someone who's more actuarial, engineering, accounting kind of personality, adjuster type, where there's details and there has to be reasons for the details, and the numbers will come with the actual number and the price tag and the explanation for the why of them, right? Looking at the teams all together, do you have an even match between the teams, or do you have a power imbalance? You might see differences in terms of skill, in terms of the attorneys or even the people involved, just knowledge of available to each person. You might see a difference caused by the money that different sides have available to them, or even the preparation, right? How much homework did they do before coming into mediation? Did they just roll out of bed and show up? Or did they really put their time in to be prepared? Everybody loves a backstory. I think as mediators, it helps us connect. And so in terms of sport, you have the good guys, the bad guys, the powerhouse team, the Cinderella team, who's, even the labels plaintiff and defense, carry sort of that flavor for backstory and the names of specific firms or particular lawyers, or here in the picture, you have Megan Rapinoe in the pink hair. And so Megan Rapinoe walks in, you kind of know who you're dealing with, right? But somebody else could be not as well known. How are they interacting? How are the different sides interacting within the team, right? And also with the other team. Those are kind of the dynamics and that you're watching as far as interaction. And how are they communicating with each other? And I put that quote in there, it's not the intent, it's the effect. People might think they're making a fair offer or a conciliatory presentation, or maybe they're coming out aggressive to try to scare the other side. They come in with all the purposes for what it is that how they're gonna communicate, but you as a mediator are watching for the effect it has on the other people. Sometimes it has the effect that the other side actually wanted, but sometimes it backfires, or sometimes even if it did have the effect that the other side wanted, you're gonna be dealing with the cleanup. So, and lastly, just where is the locus for decision making in this team and this group of people? Who's in charge? How are those decisions going to be made? And you have sort of the concept of authority to settle, right? But there are lots of flavors and nuances to what that looks like, and so you can get a sense of whether you have the senior person on the team or just a younger associate who got sent in to cover, might not be as familiar with the file, whether there's more authority that's not in the room that you might have to figure out how to access later on in the process. So who are the teams? What is their goal? Got to have a soccer for the goal, right? How are they defining success? What is it that they're actually trying to accomplish at this mediation? Do they have, and this I think is driven in many ways by the parties, do they have sort of a win-lose kind of binary framework that they are operating under? And sometimes people define settling as lose. And so that alone has to be reframed in order to be effective in some instances. Or are you dealing with a definition of success that's multifaceted and sort of weighted based on several different factors? You're going to get more of a sense there as you watch the shifting positions, as you uncover the underlying interest for why someone has a particular position or not. And why it is that they're trying to accomplish, but what is their end game? And in many instances, you might even get this from reviewing a docket in advance to see how far along this case is and what kind of factors might be pressing on one side or another. Is this mediation an intermediate step in the process? Has discovery not yet been done? The trial date is sort of far off, or they might have a little hearing around the corner, but nothing for final pressure. It might not be ripe for resolution, that concept of ripeness, the idea that it needs more time before it's actually ready to go. And maybe on the other side, you have people who are there to get it done, who want to end the litigation, they're invested in a settlement. But that's the question, right? Do they seem invested in a settlement, and can that, is that going to sustain the outcome, right? Is that going to drive the outcome here? What is their strategy, right? So we're talking about how sport has a lot of great metaphors for negotiation. And negotiation is, mediation is facilitated negotiation. It's just what one side wants versus what the other side wants, and everybody trying to kind of get there, right? And so, you have all these ideas, these concepts out there, like crush the opposition, or try not to get crushed or lose your shirt, or they're lucky if they win, or, it's a balanced team and there's lots of paths to a successful end game, right? Good defense, good offense, lots of tricks in the bag, and players available, right? So one good way to kind of see what strategy is being pursued by a particular team, as it were, is to look at the playing style that each side is using. And this is an old model. It's been around for a long time, sort of in the early days of mediation, the Thomas Kilmann model. You can actually take the Thomas Kilmann conflict styles inventory. There are several versions of it out there online that will rank you in this style, in these styles. And everybody has some aspects of all of them. Some are just more salient for some people than others. And in some instances, you have people who are balanced across the board. But the two kind of axes are the idea of assertiveness. How much do you stick up for what you actually want? And cooperativeness. How much are you willing to work with the other side for them to get what they want? And so up here in the top left, competing, high assertiveness, low cooperativeness, the idea that you're going to push for your perspective above all others, right? You don't really care what the other people want. You just want what you want, right? One spot over to the right is the collaborating conflict style. And that one is high assertiveness, but it's also high cooperativeness. So you have a lot of problem solving activity there, and you have groups that are working together, different sides that are working together to develop a mutually beneficial solution. So an outcome that works for everybody there, right? Which is different from compromising, right? Compromising is more in the middle. It focuses on what you're willing to give up and what the other side is willing to give up to end the conflict. Everybody is willing to give something up that they want to get to the actual end, right? And so that's the difference between collaborating, where you might actually create something a little bit different where everybody else gets what they want, to compromising, where everyone's stepping away from what they want in order to get something that works for everyone. So, and that's a more medium assertive, medium cooperative conflict style. And there down on the bottom right, you have accommodating, accepting the other side's perspective and ending the conflict, right? So high on the what the other side wants, low on the assertiveness. You step away from what you want, you step towards what it is that the other side is asking for, and it does also end the conflict. All of these have the capacity to end a conflict, right? And last but not least, avoiding, stepping back, not engaging, letting the conflict play out. Low assertiveness, step away from what you want, but low cooperativeness. You're not necessarily pushing for the other side to get what they want either. You're just hoping it's going to resolve itself. And all of these are useful depending on the set of circumstances. I don't think anybody can be married for 50 years without doing a lot of accommodating. And a lot of times when things get hot, stepping away and avoiding things for a little while is not a terrible strategy, right? If you don't compete in some cases, you might not end up with what you want. And collaborating, I feel like collaborating is sort of like the win-win mediation happy place, right? But it doesn't mean that it's necessarily better than any of the others, right? The compromising and collaborating formats. So what's the risk? One of the other functions in our facilitated negotiation that we are performing for the people who are coming into mediation is we're helping them evaluate risk. Mediation is the first day that people walk in the door and actually have to face off with the other side in some instances. Maybe they've had some depositions or discovery, but really everybody's marching onto the field, as it were, with a unified front and believing in their team, right? Hopefully they've done some good risk assessment, but if they haven't, it's going to happen live, right in front of you, right? So you're sitting there helping them visualize the alternative futures. What if? Wonderful question, right? What if this happens? What if that happens? It's not happening right now, but in the safety of caucus, let's play out what might actually happen if a particular future should come to pass. And if people are not comfortable in making certain kinds of offers, you can use something called a trial balloon to test the other side's reaction. Which can be attributed either to the parties or to the mediator. You can say, hey, what do you think this would be? What do you think if the other side offered this? It's an if, right? Or how about this idea with no attribution, right? Once you generate all those options and outcomes, you can help people process them by creating that full list and helping each side rank them. What would you like the most? What would you like the least? And it's going to be different from what the other room is going to say. Here's what we would really like. Here's what we really wouldn't like. But you might have some overlap somewhere there in the middle, especially when you compare the potential outcomes. You can kind of see what some of the better solutions might be that everybody could live with and would resolve the issue. If one side is to the point where they're willing to walk away, right? High tolerance for risk, we want to go to trial. You really need to test the idea of whether they've had that detailed conversation about the reality of going to court. And many times they just have the concept of going to trial and not the reality, not the time consumption, not the money that needs to be dedicated, not the mental stress and effort that's going to be implicated. So a lot of times we can kind of push them up against that in order for them to really weigh it as a riskier option, should that be the case. And then there's the getting the yes kind of factors, the alternatives, right? You can ask each side, what's their best alternative to a negotiated agreement? What's the worst alternative to settling this case? And what could be the most likely alternative? Nobody has a crystal ball, but experienced attorneys in particular should be able to use the most likely alternative to a negotiated agreement to nudge their clients towards considering a good settlement option that they might be infecting, right? So what's the score? Everybody keeps score in their head, right? I like this picture because it's in football, you have the chains, right? And you're trying to advance by moving the chains, and the chains are essentially a range, right? A range of yardage on the field. And so each end to me works like an anchor, right? So when you're dealing with anchoring, the concept is where do you drop your anchor? Where do you make your mark that you don't want to move from? How far will you sort of drag that anchor in the direction of where you can go, right? Who goes first is always interesting. And what is the reaction that the other side has to a particular initial number that gets thrown out, whether it's an offer or a demand, whatever it happens to be. Establishing a range is, I think, important. I don't think the parties are always conscious of it. In some cases they are, but sometimes they're not. So you as a mediator, I think, need to watch for that, where one side is versus where the other side is, and how far apart, where is it that they are? How far apart are those anchors? Where is the midpoint? Midpoints are sort of a natural place where people look. It's not always the quote best place for either side, but it is sort of a natural place to look. The more prepared sides will have planned negotiation steps and started high and given themselves some room to wiggle, basically. And sometimes they'll actually, if they trust you as a mediator, or hopefully if they haven't had a traumatic experience with a past mediator who gave it away, they might share their limits with you, but not always, right? In some cases, you won't be privy to that information. But what you can pay attention to is what are each side's expectations? What kind of nudging needs to happen to raise an offer, to lower a demand, and to get them into a place where their two ranges might overlap, right? So each side comes in with a different range, but the place where the case is going to settle is known as the zone of possible agreement. That's when you feel the wind in your hair, because now they're close enough, right? Now the idea of what each side thinks is possible is close enough to the point where we might actually get this done here. So I'm going to hand it over to Sherry here, and she's going to talk about the mediator's role.
Thank you, Christina. Thank you for that overview about the global viewpoints and how we look at this as sort of a bigger picture. I'm going to now focus in on some of the more narrow things and more the narrow tricks of the trade, which we can all use as mediators and as humans. First is the mediator's role. I'm going to just point out the big three: neutrality, confidentiality, self-determination, and leave it there. The second thing to point out is you are a referee and a cheerleader. You're the least important person and the most important person in the room. You are actually not playing the game, but you need to be there to urge everybody on and to keep them on point, and if necessary, be the referee to bring them in. You don't always need to be a referee. I much prefer to be a cheerleader, but you do have to remember that you're the person who needs to come in if things do get out of line and keep yourself on track. I'm reading from Florida Statute 44.1011. The role of the mediator includes, but is not limited to, assisting the parties in identifying issues, fostering joint problem solving, and exploring settlement alternatives. Why am I boring you with Florida Statute 44.1011? The reason is because people sometimes lose track of what a mediator is supposed to be. There's a lot of belief that a mediator just conveys information from one room to the other. They call that almost like a letter carrier. That is not what you do. Your role is much bigger than that. So I'm going to go to the mediator's playbook now. And what I'd like to point out is something called the amygdala hijack. We don't have time. We could do a whole session on the amygdala hijack. I'm not going to do that, but I would like you, if you've never heard of that, to go look it up. The amygdala hijack is, we basically have two parts of our brain. We have the rational and the irrational part. And the amygdala is basically the fight or flight. It responds when you're scared. It responds when you're angry. It could respond when you're hungry even. But basically, if you've ever heard the expression seeing red, it basically means that you are reacting in a way that maybe if you were in the fight or flight situation might be rational, might help you preserve humankind, but really doesn't help in a negotiation. And so honestly, you always want to be looking out for the amygdala hijack. You want to know when you see it, not to take it seriously, but understand that your role is to remove it. So how do you remove the amygdala hijack? Number one, you listen. People need to be heard. And if you remember nothing else about this presentation, please remember, you are there to listen. You are not there to convince, persuade, tell everybody how smart you are. Never use the word I. It's always about them. You need to listen. Another way to remove the amygdala hijack is to mirror. Again, we don't have time for a full session on mirroring. If you've never heard this term, please go look up mirroring in terms of negotiation. I'm going to give you the short version. It basically repeats the last 3 basic words or concepts a person said. If you want to make a person feel heard, mirror them. Now, don't make it obvious and don't do it too much, but it is very important to actually make people feel heard. And mirroring is one of the Jedi mind tricks that people use to make people feel heard. Another one is validating. That doesn't mean you're agreeing with somebody. That doesn't mean you're taking someone's side, but it does mean you are hearing them. It is telling them back what they've heard and understanding and relating to them. You're not sympathizing, you're empathizing, and it's tactical empathy. And it's very important that you as a mediator understand tactical empathy. A lot of us do it naturally because we just care. And so it just comes out naturally. If it's not something that you actually have naturally, you have to understand that tactical empathy is really important as part of your role. You have to make people feel understood, validated, and heard. Another trick of the trade, emotional labeling. We talked about the amygdala hijack. If somebody is angry, if somebody is mad, depending upon whether it is in a room where everybody is together or in caucus, one way to effectively interfere with that amygdala hijack is to label. You want to say, it seems like, never use I. Don't say I think or I believe or I am seeing. Never use I. Just say, it seems like you are angry. It seems like you're upset. For whatever reason, emotional labeling stops people in their tracks. You don't need to say anything else after that. You actually want to go quiet. You want to be quiet after you've emotionally labeled. Give them a chance to get their thoughts in order. I try to say, it seems like you're upset, rather than it seems like you're angry, because nobody wants to be labeled as angry. On the other hand, that's strategic. If somebody really is angry and you say, it seems like you're angry, you're actually going to find they're going to be so busy defending the fact that they're not angry and explaining to you what they actually are, which is different than anger, that it will actually eliminate that amygdala hijack. It will bring you back to square one. So emotional labeling is very powerful. Again, Jedi mind trick. It's a very powerful tool. It can get you back on page. Framing is another mediator playbook trick of the trade. There are ways to say things. You can say, we're here to resolve these issues, and if we don't resolve them, we're here to understand them and be able to go back to square one to understand what our issues are. You don't say we're here to resolve these issues or to impasse. You try to keep framing in the positive. It's a difficult tool, but it's a very powerful tool for most people. And as a mediator, you need to keep them framed in the positive. What else is in the mediator's playbook? Well, remember we talked about listening. Listening means reading between the lines. What people say versus what they mean, which is often very different, as I'm sure you know. Body language. Don't judge or jump to conclusions. Wait. I just spoke to somebody about how they had negotiated a loan, and they thought that the lender was going to give them compound interest, but the lender was actually going to offer them straight line interest. They were going to negotiate over the percentage of the interest rate. They didn't actually have to, because they did not speak up. They sat back, did not make assumptions. When they found out that the lender was doing straight line interest instead of compound, they grabbed that loan because it was much more favorable than they thought it was going to be. Another tool of the trade is repeating. When you hear something that somebody says, particularly at the end of caucus, also, in intro, you can basically repeat back what you've heard, and that will give them an opportunity to correct you or know that you've heard them, and also consolidating and organizing, because people can go off track. So pre-gaming, if it's a simple issue, you don't need to have a pre-mediation conference, but if it's not, I highly recommend, I think the biggest trade secret that mediators don't use and should use is pre-mediation conferences. Lawyers really appreciate that if they know that you want to know what problem you're solving and how you can help them. It doesn't mean that you're giving your opinion. You're not imposing yourself. We do this job better by listening. We can learn what matters in the case, on the issues, learn the decision makers. As Christina Maldonado pointed out, it's very important to understand who the decision makers are. because those are the people who are going to help you get to the solution. Also, understand the pain points for leverage. What's coming up? Is there a trial date set? Is there a summary judgment motion pending? Is there a key deposition? These are things that are going to help people get to a solution. Again, I'm just going to repeat this, and I can't say it too many times. Listen, this is not about you. This is about them. Starting the match. Your opening statement, different people have different versions of opening statements. Some people want a longer one. Some people want a shorter one. One thing I will say is don't make the opening statement about you. Welcome and introductions are very important. I basically say, my name is Sherry Alessar, please call me Sherry. And then I want to know each and every person in this room, what they want to be called, how they want to be referred to, whether we're going to go informal with first names only. I've sort of given them the lead for that, but if they want to use their last names, I need to know that. If it's live, I want to make eye contact. I want to make a connection in some way with everybody in that room, preferably even before the mediation begins, but certainly when the mediation begins. If I can't do it live, if I'm not doing eye contact, I can do the same thing virtually. I can ask them their name, how they like to be preferred, how they prefer to be called, and then just, connect with them in some way. It's very important to make every single person in that room feel included. So what is part of starting the match? Defining the problem and understanding it better. I'm going to give kudos to Art Garcia. Basically, his point with opening statements is, let everybody know the plaintiff isn't going to convince the defendant, and the defendant is not going to convince the plaintiff. But at the end of the day, we are either going to resolve this, or we're going to have an informed decision about why we didn't resolve it. We're going to understand what's standing in our way. So either way, the mediation is purposeful. We're either going to get an education, or we're going to resolve this. And that brings me to my next point, reframing negativity into positivity. How I just phrased that, we're going to resolve this or figure out what is standing in our way. I could have said we're going to resolve this or we're going to impasse. I want you to think how important it is to keep everything on a positive level. Anytime you can frame something into positive rather than negative, into a win rather than a loss, take your opportunity and do that. Control the narrative. Your tone of voice tells the room how to react. Other people may have come in, excited or aggravated, but you are there to get the level down. Framing is very important. This is part of the narrative. Basically, we talk about challenges. We don't talk about this person is wrong or this is a bad thing or that's a bad thing. We talk about our challenges. We frame things in a way that can be constructive when we can. Visualization is another really nice Jedi mind trick. I try to tell people, think about tomorrow morning, you're getting your coffee and you know that this is behind you. That big sigh of relief, when people know that this is done, that is going to help them get there. If they can visualize it, if they can want it, if they can see it, that's going to help them get there. You get to decide when the right time to do that is. I tend to do it later rather than earlier. The other way you do control the narrative is summarize and organize. Make sure people don't go off course. So you're going to repeat what they've said, but you're going to consolidate it. Also, if needed, set the rules. You are basically there to make sure this is a good game. Christina Maldonado explained to us how we have to look at the parties, the decision makers, all of that. If you know you are going to be dealing with somebody who is going to make trouble, then set the rules early. Talk about how we're going to treat each other in mediation. Most of the time, I don't have to do this. Most of the time, people are professional, but every once in a while, it's a good idea to set the rules. Caucus. What's most important about caucus is what we've been talking about the whole time, the amygdala hijack. People need to feel safe. Although you can't give them legal advice, you can ask the right questions. You can, lead them down the path where they're going to be giving you the information. You're not giving them the information, but you get it from them by asking the right questions. My next point is from Karen Evans Putney. She is an extremely intelligent mediator. She talks about mediators advocate out of both sides of their mouth. Well, what does that mean? That means when I'm in caucus, I am doing tactical empathy. And again, this to me comes naturally. I definitely want people to feel comfortable. I definitely want them to feel safe. Whether that's whether that's in your nature, and I'm sure that is in a lot of people's nature, that's part of what makes a good mediator, or it's not, you need to understand how powerful tactical empathy is. When you are in room with one set of people, you are empathizing with them, you are listening to them, you are validating them. And when you go into the other room, you're doing exactly the same thing. Manage expectations. Before you leave caucus, review what you're going to do, talk about the confidentiality, what you can say, what you can't say, and plant seeds for the next round. What does that mean? You're giving them homework. Unless you know that what you're taking to the other side is going to be a win, you need to manage expectations. You need to tell them, I'm going to go in there and I'm going to make your case and I am going to be your best advocate and your best friend. But you need to understand their expectations, where they're coming from. And we need to be able to think as much as we can about the next round. So while you're going in there trying to get their best number, they need to be thinking the other side isn't going to accept my best number. And I need to start thinking about other solutions. And this is, by the way, it's not just numbers. It can also be creativity. Play number one, reasonable proposal. Christina talked to you about the different types of negotiation tactics and different types of negotiation players. This is the ideal situation when you're dealing with reasonable players and reasonable proposals. So how do you respond? I'm going to give you different types of things, different types of techniques, but they are not necessarily just for reasonable proposals. They're for everyone, but we're going to try to classify these based on the different types of negotiation styles. So what is your mediator tactic? How do you respond to reasonable proposals? Ask questions, tell me more, keep them talking. You can get ideas about where they're going to go and what they're going to do if you keep them talking. Keep it positive. Visualization of a positive outcome is very powerful. If they are positive people and they can visualize a positive outcome, that will keep them on their track. And by the way, as a mediator, you need to filter out what people say before you repeat it to the other side so that you can keep that positive spirit on both sides. Reciprocity. Reciprocity is very important to reasonable people. I have seen mediations go 10,000 down, 10,000 up, 10,000 down, 10,000 up. And I've stopped people before they've told me 5,000 up. And I've said, do you see what's going on here? And gotten them to, rethink that offer so that we just kept going until we hit actually a better number than they actually thought we were going to hit. So understand the power of reciprocity and how you can get people to bring forward a better offer if they believe and understand that it will work in the other room. Now, you can't use this with difficult people because you can't have reciprocity if there is only one person doing the offering. So you have to judge, like Christina told you, what are their styles? What are their mediation styles? Are they win-win people or are they win-lose people? You need to know who you're dealing with when you make decisions about how to use what mediator techniques will work best. And then, of course, move on to solutions. Keep them thinking. Ask them how. Play number two, aggressive outrage. Okay, this is not the mediator's picnic. This is the mediator's nightmare. Although some people consider this a challenge. Mediator tactics, how to respond. Number one, keep your cool. Don't play into it. Don't respond to it. Make sure that you are responsible for keeping the tone where it needs to be. If you need to play referee, reorient. We attack the issues, not the people. I try not to play the referee as much in caucus. If everybody's in the room, sometimes you have to play the referee and you remind them that mediation is an arm of the court and we treat each other in here as we would in the courtroom. That may or may not work with some people. You have to decide for yourself what kind of referee you want to be. You can empathize, but you also need to keep people in order. Break the amygdala hijack. Again, tactical empathy. People want to be heard, so hear them. This is more important in caucus. If you are talking with people in caucus, you can actually let them go off. If they're really angry, if they're really sad, if they really need to be heard, let them. Eventually, you'll have to pull them back in. You'll have to keep them on point. One way I do that is I remind them that it's their mediation and they can use it however they want, but they're paying me by the hour and I would prefer that they not pay me more than they have to. So if we can keep it to things that will help get to a solution, let's try to do this. I remind people there's a difference between litigation and mediation, and litigation is about the fight and mediation is about the resolution. And I try to get the lawyers to keep their resolution hats on. Sometimes it's the lawyers who are their own worst enemies, and you just kind of remind them about the fact that we're here to resolve and hopefully bring people back onto the path. Emotional labeling, this is a Jedi mind trick. I don't know exactly why this works. I just know it does. I wrote, I see you're really upset. Technically, you don't want to use the word I. You want to say it seems like you're really upset. Anytime you're using the word I, you're probably making a mistake. But it seems like you're really upset is very helpful, or it seems like you're angry is very helpful. That breaks the amygdala hijack. They have to respond to you. What you do is after you say it, go quiet. Don't keep talking. Let them respond to you. That will allow them to reorient. People do not like to be told they're angry, so upset might be the better term. On the other hand, strategically, if you tell somebody, it seems like you're very angry about this, they probably want to correct you and not seem angry. And again, that breaks the amygdala hijack. It is absolutely a wonderful trick. It totally works. And I encourage you to use emotional labeling when you see the emotions getting out of hand. Of course, I would start with listening, tactical empathy, but then eventually you have to use another technique, and emotional labeling is a good one. Do not be intimidated by posturing. Lawyers believe that their clients want to see them be aggressive and be outrageous. I don't necessarily agree that is, that's not my style. Christina told you that there are different styles, and there's all different types of styles. But posturing can get a little tiring, especially as a mediator when you're trying to get resolution. Don't be intimidated. Let them do it. It's something that they need to do. But I want you to understand as a mediator that not only do you not need to be intimidated by it, but you need to frame it in your own mind that there's often a correlation between how outraged they are and how outrageous they are. A lot of times there is a correlation between how much people expect of other people, how entitled they are, and how little they expect of themselves. So just understand that's about them. Don't buy into it. Don't lose your cool. Play number 3, won't budge. Well, I think this probably happens a lot. The first thing I want to let you know is let them say no. That's a scary word. No, no, no. But you actually are empowering them by letting them say no. Once people can say no, it's not a final no. They need to hear themselves say no. Then they can get back to the rational brain. So if they want to say no, let them. If you are dealing with somebody who is asking for something unreasonable, one way to handle that is to use the word how. When we talked about asking strategic questions, if you use the word how am I going to get the other side to agree to $1 million? How is the other side going to pay $1 million? They're actually going to respond and try to think for you and for the other side. And they're doing the work for you. This is another one of those Jedi mind tricks. If you actually use the word how in response to an unreasonable demand, and don't overuse it, but use it very, sparingly, you are going to find that the other side is doing the work for you. Another strategy for when people don't budge, is brackets. Some people don't like the word brackets. I've heard it called reasonable ranges or contingent offers. If you do not know what brackets are, again, homework, the Young Lawyers Division Mentoring with the Masters, Michelle Jernigan on bracketing. We have the YouTube link here. You will have this as part of your handouts. Go watch it. Basically, it means simply you have a range. So if somebody is looking at 50,000 and the other side is looking at 3 million, you might create a range. You want them to create the range, but you want them to start with a range. And basically the range could be something like, 100,000. If they promise to not go lower than 100,000, can you promise not to demand higher than $1 million? And I'm just throwing that out as an example. A range can be anything and people can go back and forth on ranges. A lot of contemporary thinking believes that ranges should be set so that the middle is where you want to get. That doesn't necessarily have to be the case, but a lot of people do follow that rule. So again, won't budge. More mediator tactics, how to respond. Number one is choices. Choices are an amazing tool. If you go in there and say they want you to do this, then you're just going to get a, I'm not doing that, or no. If you say they are giving you a choice between A or B, you are suddenly empowering people. And if you think about this in terms of a young person, like if you're asking your kindergartner, what do they want for lunch? They may look at you and stare at you blindly. If you ask them, would they rather have a hot dog or macaroni and cheese, and please don't judge my food choices, now you are basically giving them a choice. And you're giving them an opportunity to participate, and you're empowering them without waiting for them to come up with solutions. So if you can leave a caucus with 2 choices or 3 choices rather than one, do it. It empowers the other room. It gets them thinking. Even if they don't like either one of those choices, they're going to start thinking about how to negotiate the other choices. Here's another trick that you can use for choices. It's called the reverse Godfather, and I have to give Peter Grilly kudos for this one. We've all heard of the Godfather, an offer you can't refuse. Well, a reverse Godfather is an offer they can't accept. And how do you use a reverse Godfather? Well, we talked about the choices. Well, honey, do you want macaroni and cheese, a hot dog, or, spinach? Well, or fish sticks. It just depends on your child, of course. And maybe some of you are bringing up your children to eat fish and spinach, and I commend you. But for those of us who weren't as good as that, a reverse Godfather means that somebody on the other side isn't going to like one of those options. And this is a very strong marketing tool. In marketing, the marketing people will actually try to get you to pick the central option. And you sometimes see it online where there's a small, medium, or large option. I'm not talking about French fries. I'm talking about like software subscriptions. The very high-priced one we're going to reject. The very low-priced one isn't going to have the features. The middle one looks really good. And the same thing happens with the reverse Godfather. If you give people choices, they're going to feel empowered, and the choices are going to start to look better if you throw in a reverse Godfather. Finally, there's John Selman. I'm giving him credit for the purebred dog creativity. It's not just about money. Think of solutions. People were arguing over a purebred dog. Well, John came up with a solution. Let's breed the dog. Now everybody can have the dog of their choice. It worked. So just keep your mind open. It's not just about money. All right, when all hope is lost, we're totally tapped out. Ask for suggestions from the parties. Ask this question: have you given up on resolving this outside of litigation? Don't ask me why this works, but people do not like to be asked, are you giving up? That makes them think maybe there's something else that can be done. And I credit that to Chris Voss, Never Split the Difference. He was the lead negotiator for the FBI for hostages. Understanding you can't split, I'll take 2 hostages, you split 2 hostages, you can't split the difference, you have to get this done. They have a lot of wonderful negotiation techniques. I highly recommend it. Christina was talking about getting to yes. That was Harvard Business School's lead negotiating book. And the follow-up to that is Chris Voss's Never Split the Difference. And that actually does a lot of discussion about emotions and handling people's emotions. And that is actually a very successful book in terms of dealing with that. Trial balloons, I want to credit Christy Foley with this. Ask them a question. If I could get them to do this, can I get you to do that? Based on their response, Christy has said, if they say, no, absolutely not, she knows where she's going. But if they think, if they pause, Christy thinks that is a real high signal. Can't 100%, but it's a pretty big signal that they're going to take up that trial balloon. That is one step. A mediator's proposal is another step. People don't want to be cornered. They don't want to say what they're going to do. So sometimes, and this truly is your last step, it's the mediator's proposal. They've stopped at 100. The other side has stopped at 300. I come in and say, I'm giving you a mediator's proposal. This is perfectly legitimate in mediation. I am giving you a solution. You've stopped at 100, you stopped at 300. The mediator's proposal is 200. If I was going to do this live, I would hand them a piece of paper and I would ask them to say yes or no. And by the way, I wouldn't just talk about the 200,000. I would talk about any key issues, dismissal with prejudice, whatever things that are important to the parties. And then they would say yes or no. And the reason a mediator's proposal works is nobody has to admit that they would say yes if the other side said no, because I'm going to take those pieces of paper and I'm going to read them. And if one person says no, everybody says no. I'm reading them to myself. I am not reading them out loud. When I do this virtually, I just do the same thing in caucus. And basically, nobody has to take responsibility for that. I'm responsible. Adjournment. If it doesn't work, get the best last offer, keep it on the table, and talk about coming back or calling in 2 days. Always try to keep negotiations over. This isn't over just because the mediation has ended. If you really care about your role as a mediator, you follow up. So post-game, you follow up, you check in, you watch the case for leverage. Is there a deposition of a key player coming up? Is there a summary judgment motion? Is there a trial date coming up? Make those calls. They will really appreciate it. And I will tell you, I have left mediations and picked up the phone 5 minutes after mediation and spoke to both lawyers and said, this case should have settled. Had both lawyers agree with me, and 20 minutes later, it was, after speaking with their clients, it was resolved. So don't be afraid to make that call. It's not over just because the mediation has ended. And you can have solutions-oriented post-mediation discussions. And I will tell you, even if they do not resolve the mediation, those lawyers will appreciate you and they will understand how much you care about what's important to them. So I'm going to turn this over to Christina.
Thank you, Sherry. That was an excellent presentation on all of the tactics and when to use them, and ways to help people get across the finish line, as it were. To the point of the whole referee and cheerleader, right? Hopefully you sustained everybody's spirits throughout the process, and without getting discouraged, they made it to the end. As a ref, you ran a clean game, right? You didn't let things get out of hand in such a way that this is now just one more case in the books, right? The parties will go on and hopefully they're not in mediation all the time. Think of this as a positive experience and a productive one. Something that they're glad that they tried. And for the repeat players, you want to see what you can do to sustain those relationships, right? The relationships between the parties and the councils. You want the clients to be satisfied with their lawyers. So they'll go and they'll get those good reviews. You want the lawyers to be satisfied with you so that they will use you again. You want to sort of spread the courtesy and appreciation around in terms of good game, great work, well done, everybody worked hard. And that kind of an encouragement at the end. If it was a bit of a rough game, and sometimes they are, you want to help people pull something from the wreckage, right? In terms of learning from what their perceived loss and what it is that they could have done differently. People do appreciate the opportunity to kind of think out loud about how what they could do. And Sherry's example of calling afterwards is a good way, a good technique to deal with that. At one point, this is not sport related, but I remember reading Neil Gaiman novel, graphic novel, and it talks about the spirit of the staircase. All the stuff that you think about after you walk out the room, close the door, and are walking down the stairs, right? A lot of times people are going coulda, shoulda, woulda. There's a lot of Monday morning quarterbacking, if you will, right? But it starts immediately afterwards. Right? What if I'd done this play differently or done that differently? And sometimes the end of mediation is kind of an artificial end, right? Because those negotiations do continue, and it ain't over until it's over, on the courthouse steps, in front of a jury, in front of a judge, whatever happens to be. So there's still a lot of opportunities. There's an extended, there's repeat matches for the repeat players. So you want to be able to kind of have people have that incremental experience and just do what you can to make them feel positive about the whole experience, because we're there to as ambassadors of the process, right, as well as guardians, if you will. So that's it for our presentation. Good game, right? GG, as my video gaming 10-year-old will tell you. Here's our contact information. We're glad to speak to anybody who wants to reach out via phone, email, whatever it is we can help you with. We are a la orden, at your disposition as things go. And Sherry, do you want to add anything here at the end?
Absolutely. As mediators, we spend a lot of time doing this on our own without a support system. And it is very important for mediation. Florida is the leader in mediation. It actually was one of the first states to create mandatory mediation. I attended a seminar in New York where they said, we want to catch up to Florida. Other states are looking at us. We are creating something that can be of value in litigation from, you know, today forward. And however we can help each other, we should. We need to empower other mediators to empower this profession, because it is critical. As you know, litigation just keeps getting clogged up. It is critical that we empower mediators and empower each other. Anybody should feel free to call me at any time. If I'm not there, I will call you back.
Thank you, Sherry. And I do want to say one last thing here. It has to do with the alternative dispute section of the bar. Only attorneys are admitted as members if they're a member of the bar itself. But for those of you who do, who are able to join, we'd love to have you. It's the friendliest section of the bar, as the saying goes. A lot of good communications regarding continuing legal ed for your CLE credits, and updates on any kind of rule change or discussion of those rule changes as they come out. We tend to hear about them first, and it's a good forum to have those conversations as well. And we do have networking activities and educational activities. Sherry mentioned the Mediation Mentoring Academy, which took place this year, and the Arbitration Academy is going to take place next year. There's an annual retreat for section members that is in person. Now, in the post-COVID world, it's come back to that, as well as come October, chances are we'll be doing some activities and maybe something in your neck of the woods for Mediation Week as well. So that's the website, flabaradr.com. And it's just a little bit more on top of your annual bar membership, and you should have just renewed. So feel free to just add that on, and we hope to see you as members, those of you who can.
And I just want to add to that, Christina, thank you so much. This is for attorneys only. Those of you who are not attorneys, we still think you're great mediators and we love you. But this is the ADR section of the Florida Bar. So it is an attorney only membership. For those of you who are attorneys, it is invaluable to have these monthly meetings to get updated on the rules. And also there are monthly meetings where we talk about strategies, where we talk about issues. You know, we don't come out of the womb understanding these things. And the more we can help each other and the more we can empower each other, the better off you will be as mediators. So thank you so much for coming today. And that is our presentation.
Thank you.